morning. I could go on all day about title because I'm like a title geek, but I've decided to put this down to 4 topics in terms of closing errors you can avoid. And in no particular order, those are order early, order often when it comes to your title commitment, order gap insurance, order a closing protection letter, and read the title commitment when you get it. So in terms of order early, order often, the first thing I want to do is introduce to you your local title representative, my very good friend Charlene Larson and Julie. They are both here with St. Croix Valley Title. They are somebody you should know, wave you guys, because they are your local face. I'm the go-to when everything goes to hell in a handbasket and the deal's not closing. That's when I get the emergency phone call. So my order early, order often, I think that is so important, especially in the market that we're all living in right now, where you don't know whether or not your next deal is going to be a short sale. I think we all sort of assume that it'll be a short sale, but unless you get that title commitment and you take the time to look at that thing and figure out what's in it, you might not know whether or not what you're dealing with is going to be a short sale. And I would say, for realtors in the room, I truly think that you should order that title commitment at the point that you have the signed listing contract. I would not wait until you have an accepted offer to purchase to order that title commitment, because that title commitment is going to have in it a lot of valuable information that you as a listing agent can use as you're marketing the property. Don't you think it's kind of important to know early on in the process who's in title? Because I sure think that your listing contract should be signed by the proper title holder. Now, I'll grant you that the listing contract says that if you bring a buyer who's ready, willing, and able to close, under the terms of your listing contract, you have earned your commission. But I would not, as an agent, want to give any wiggle room to my sellers in terms of getting paid after all the work you guys go through on that listing contract. Getting the title commitment is going to show you who's in title. Is it a trust in title, so that you can be very certain that what you're going to give is a trustee's deed, as Adam mentioned on the offer to purchase? Is it 2 people in title? Is it 1 person in title? What do you have to deal with in terms of Homestead? All of those things are on Schedule A of that title commitment, and that's going to help you as soon as you've got that listing contract signed. If you look at the title commitment early, and you don't do my favorite, which is look at the title commitment 5 minutes before the closing, which is scheduled for 4 o'clock on a Friday, and then you look at the title commitment and realize that you have to have a probate started, which isn't going to happen at 4 o'clock on Friday, and then I get the call and I'm looking at my watch going, really? It's like 10 minutes to happy hour and I have to fix this? I can't. So look at that title commitment and specifically look at Schedule B, Section 1. That's the requirements page, and that's where we're going to tell you everything that needs to happen from a title perspective prior to your closing. Take a look at Schedule B, Section 1. Hone in on what your seller has to do. You don't need a buyer in order to order the title commitment, because when we do the search, we're searching the land records and we're searching the seller. Schedule B, Section 1 is going to give you your first clue. What if the parties are divorced and title is still in Jim and Lisa Petersen, and you're dealing just with Lisa Petersen, but that title commitment shows Jim is still in title? Well, I don't get along with my ex-husband, so I would not want to have to deal with that on the day of closing. That's something you're going to want to get me working on well before you have a buyer. What if a probate has to be opened in order to close your deal because they held title as tenants in common? That's not going to happen quickly. Why not get those things moving well in advance of closing so you're not faced with 4 o'clock Friday, gee, now I guess I'll look at that title commitment and figure out what has to get done. It'll give you a great idea of what your seller has to do moving forward. Then don't stop at Schedule B, Section 1. When you're looking at that title commitment, look at Schedule B, Section 2. Schedule B, Section 2 is where we list for you all of the exceptions to title, all of the things that affect the title and affect the people. This is where you can start looking at things like what restrictions affect the property. That might help you in terms of marketing it. You've got a buyer that comes in and says, geez, I can't wait to, I can't wait to buy this vacant piece of property and put a multifamily dwelling on it, and then maybe have a strip mall on the piece I'm going to buy next door. And you've taken the time to read that title commitment, and you've looked at the restrictive covenant that says this shall be developed as a single-family residential parcel only. Isn't it better to know that when you're dealing with a buyer before they sign that offer to purchase, so that you know what it is you're selling? Rights of first refusal, options to purchase, all of those items are going to be on that title commitment. Again, don't let that be the surprise for you at the closing table when all of a sudden you look at the title commitment then and go, oh my God, the neighbor's got an option to purchase on this property and no one has contacted them to find out whether or not they want to exercise that option. Huge problem at the closing table. Then take a look at the money items. Take a look at what it is your seller is responsible for paying. Judgments, child support liens, construction liens, condominium liens, mortgages, all of those items affect the title. That is very likely to be the first time that you guys as realtors realize that what you're facing is a potential short sale. Because let's face it, you are the experts on knowing what the property is likely to sell for. We are the experts on telling you what has to be paid when the property sells, and your sellers very likely have this very lovely image of both what the property has to sell for and how much they owe on it. And as an example, I will tell you that we had a closing down in Kenosha County, and it was my classic example of nobody reading the title commitment prior to closing, and everybody getting to the closing table, and the sellers for the very first time look at the closing statement in the HUD, and what the seller's wife sees on the closing statement is a payoff for a child support lien in the amount of $60,000. Now, not only did she not know that her husband had been previously married, she did not know that he had children that he had not been paying for. You don't want those surprises at the closing table, because that one, the closer said she literally wanted like the floor to open up and swallow her, because as these people are like duking it out over this child support lien, she's like, you know, you had the commitment for like 3 weeks now. If you'd have looked at that, you could have had this fight behind closed doors. So those are the kinds of surprises you don't need. And it also gives your seller an opportunity to consider things like maybe claiming the homestead exemption. You've got a seller on a short sale, they've got 4 docketed judgments, they're walking away with 0 proceeds. That's an opportunity for them to claim Wisconsin's homestead exemption, which basically says that if you are a single person walking away from a closing with less than $75,000 in equity, or a married couple walking away from a closing with less than $150,000 in equity, you don't have to pay docketed judgments. They are exempt from a sale of homestead property only. Again, take a look at that title commitment early on. Now, as the real estate agent, it is not your job to counsel the seller that they can claim that exemption, but I think it's a good idea to at least suggest to them that they review the title commitment to look at what judgments and liens they are responsible for paying. Yet another great opportunity to get an attorney involved, especially on short sales. And as an attorney myself, I can tell you that what I hear from sellers on short sales is, I can't afford to bring attorneys into the mix. I'm already walking away from this thing short. I'm not getting any proceeds. It just seems like short sales, they're so complicated. And those of you that are real estate agents in the room, you know how long it takes to get short sales done. It takes forever to get them approved. You go through 8 million changes to the closing statement. Lots of last minute headaches. Those are the kinds of deals that you want those attorneys involved early in the process. And I sympathize with what I call the real lawyers in the room, because you guys are the ones that they come to you when the offer to purchase is already signed and then go, okay, fix this. Well, as Adam said before, you already signed it, so I can't really fix what you've already signed. So order that commitment early, take a look at it, figure out what is my seller's responsibility, and get them started on curing those defects early in the process. And then again, look at the judgments and liens and try to calculate whether or not you might be facing a short sale. If you think you're facing a short sale, get moving on that track. Call the lender, get their short sale payoff package so you know what you have to provide to them in order to get the loan approval, or the sale approval rather. And remember that when you get that payoff letter from the seller's lender on a short sale, it's not going to be your standard payoff letter. It's not that payoff that says, in exchange for $156,000, we will issue you a satisfaction. It's going to have 8 million contingencies in it that as a title company, we have to deal with as your closer. It's going to have things like, it's a sale as is. The realtor commission shall be X amount of dollars. No buyer credits are allowed. The closing must take place by May 15th or this approval letter is void, which means you start all over again. You've got to look at all those items, because remember that at the end of the day, as your closing agent, St. Croix Valley Title has to go through that payoff letter and make sure that every single lien holder has agreed to close the deal in exchange for, in some cases, $0. For those of you that are realtors, you have a fantastic short sale addendum to your offer. You've got a great short sale addendum to the listing contract. Use those. They are fantastic. Because I think a lot of times your sellers think that the only one they have to deal with is the first position lender. Because at the end of the day, yes, the first position lender holds all the cards. If they say, I'm not going to settle for anything less than everything I'm owed, and your seller knows they can't possibly meet that goal, the deal's dead in the water. But don't forget that as you're negotiating with the first lender, you still have to negotiate with every other lien holder. Because all it takes is one lien holder to say, I'm not willing to walk away from this deal with no money. If that happens, your deal will not close. My other point was ordering gap insurance, and this goes again to the residential offer to purchase. And what I tend to see happening with realtors on the offer when it comes to gap is you guys have kind of a bad habit of reading just the first couple words in the section on gap, and that's the section that says, seller shall provide gap insurance. That's where everybody stops reading. Seller shall provide gap insurance. But if you really read that section, what it says is, seller shall provide gap insurance provided that the title company is willing to give it. In other words, gap insurance is not an automatic. Just because you've got that offer to purchase that obligates the seller to provide gap insurance, recognize that the title company, St. Croix Valley Title, we are not a party to that offer to purchase. That offer is between buyer and seller. We are going to make an independent decision as to whether or not gap insurance is going to be available. And understand very briefly what gap insurance is. When you get your title commitment, it's going to have an effective date on it. The effective date is the date through which we can search the documents that have been recorded in the Office of the Register of Deeds. It is not going to be a current date. It is always going to be some date in the past. Up here, you guys had a significant issue in Chippewa County where the records there were very far behind for a very long time, and that created a lot of real nightmares when it came to closing, because you would get a title commitment, and if you took the time to look at it, you would see in May that your title commitment had an effective date of January. The effective date is significant because exception number 1 on the title commitment says that at the end of the day, when the title policy is issued, the title insurer, in our case Chicago Title or Commonwealth Land Title, we are not responsible for anything that happens between the last effective date of the commitment and the day that the documents are actually recorded. So if your effective date is January and you record your documents in May, anything that happened between January and May is not covered by your title insurance policy. That's a significant window. And some of your counties up here, it tends to be the smaller the county, the smaller the gap. I live in Dodge County, and our gap is probably a day, so I can tell you everything that got recorded yesterday. If I went down to Milwaukee or Waukesha County, I'm looking at probably a 4-week gap. And then you add on to that the time it takes to get to closing, and you have a much larger window. And if you think about what's happening in our economy now, I can tell you that the stuff we're seeing in the gap include things like federal tax liens, and they're not insignificant in terms of the dollar amounts, child support liens, docketed judgments, foreclosures starting, bankruptcy starting, all kinds of bad stuff can happen in the gap. So you do want to purchase gap insurance. Understand again that we make an independent decision on every single deal whether or not gap insurance is available. That's why, again, I said order your title work early and order it often from St. Croix Valley Title. But it really is significant because if you get that title commitment early in the process, when we're analyzing gap, what we're looking at truly is the credit worthiness of your seller, not your buyer. Because what we're worried about are judgments and liens getting docketed and filed against the seller prior to closing. So when we prepare that title commitment and we're looking at the list of liens against the seller, I can tell you pretty much immediately whether or not gap's going to be available. If I'm looking at a title commitment that has 13 judgments, 2 child support liens, and 3 federal tax liens, guess what? GAAP is not going to be available. So strike that from your offer so you're not at the point of the closing table where the buyer is saying, well, am I getting GAAP on this deal? And then we have to say no. If I'm looking at a title commitment that has a foreclosure of a mortgage and 1 judgment, I might be willing to give GAAP because I know at the end of the day, we're going to close it, we're going to get that foreclosure dismissed, we're going to get the LP discharged, we're going to pay off that judgment, or the seller is going to claim the homestead exemption. But again, ask your title company early in the process whether or not GAAP is going to be available so you know at the point that you're getting that offer signed whether or not you should strike that clause. The other 2 clauses in the offer that I want to just briefly talk about have to do with tax prorations and place of closing. The new offer to, quote unquote, new offer to purchase has been around a while now, but it does have a default in there that the place of closing will be at seller's choice. Now, if you're the buyer, if seller's choice is Chicago because that's where seller lives, guess what? That's where you're closing. And if you're not going to be able to physically go there, you're going to have to make some arrangements to have the documents get shuttled back and forth. So do look at where that place of closing is tagged, and maybe you want to change that to say buyer's lender or buyer's title company, because if you leave the option to the seller, you are truly bound by where the seller wants to close. The other change to the offer that I have seen pose some problems down in my neck of the woods is the closing proration section that says that we'll prorate the closing now at closing, but we'll re-prorate it when the tax bills actually come out. Don't pick that option, especially on a residential deal, because I'm here to tell you, for starters, the title company is not going to be the one to do the reproration. We are not going to track down the seller, and finding the seller on a residential deal can be an absolute nightmare. Trust me, from a claims perspective, I've had to track down sellers to get money back on a claim like, you know, they signed the GAAP indemnity saying I'm not a naughty seller and 13 judgments were docketed in the GAAP. Try finding a seller when you closed in January and the tax bill comes out in December and you need to reprorate and get money from a seller that you can't find. Not a good option to choose on a residential transaction where you don't know where the seller is going to be at the end of the day. Closing protection letters. I understand that there's quite a few lenders in the room, and I want to make sure that you understand how important a closing protection letter is. And I also want to tell you that there's no such thing as an insured closing. So if there are people in your market saying, close with us, we'll give you an insured closing, or we'll give you an insured closing letter, there's no such thing. What we offer to you as a lender is a closing protection letter. It is not insurance. It is a document that's issued in connection with the title insurance policy, and it has very limited protections and very limited people that are protected by it. The closing protection letter protects the lender, the purchaser, and a lessee, and that's it. A seller is not protected under a closing protection letter, and a refinancing borrower is not protected under a closing protection letter because those 2 people, at the end of the day, are not going to get a title insurance policy. The buyer's going to get a policy, the lender's going to get a policy, and if there's a lease, the lessee is going to get a policy. Those are the only 3 people that are protected under a closing protection letter. What does a CPL or closing protection letter do? It puts the financial strength of the underwriter behind the closing activities of its agent. We have contracts with our title agents, but those contracts are specifically limited to the issuance of title insurance policies. Title agents do, I would say, probably 90% of the closings in the state of Wisconsin. Lots of money is flowing through a title company's escrow account on any given day. I'm talking millions of dollars of money. In order to be sure that the money that you're depositing with that title agent is safe and secure, you want a closing protection letter. Because that closing protection letter says to a lender, to a buyer, and to a lessee, if the closing agent fails to handle your documents properly and it results in a title claim, you have an additional protection. If the title agent fails to handle your money properly and it results in a title claim, you have protection. So I'm talking about a title company that fails to make a mortgage payoff, fails to pay a federal tax lien. Those types of issues that result in title claims are covered under this closing protection letter. In order to get a closing protection letter, the title agent has to be responsible for 100% of the closing. In other words, St. Croix Valley Title has to prepare the closing statement, prepare the HUD, collect the payoffs, attend the closing, and disperse all of the money. Then you as a lender are entitled to a closing protection letter. Right now, sellers and refinancing borrowers do not have any protection under either a title insurance policy or a closing protection letter. So those are the folks in a closing that are the most at risk if the money disappears. If either the title agent steals the money or, as we've seen a lot lately, a cyber criminal comes in and siphons the money out of the escrow account without even the knowledge of the escrow agent that it's happening. Sellers who have proceeds checks bounce do not have any protection right now. And that's what I was bending Joe's ear about, because what we'd like to do is expand the coverage on a closing protection letter so that refinancing borrowers and sellers are protected under those letters in exchange for a nominal fee, so that we have some kind of a claims reserve. So again, and I have a whole packet in there on closing errors you can avoid, and I could go on and on and on because I've got a lot of fun stories. But I know that Joe's got a lot of great information for you. I've seen his presentation. It's fantastic. He's got a lot of good stuff to tell you about what's on the horizon for our industry as we work together toward getting these deals closed. So thank you very much.
Thank you.